At Blanchard's Law, we find that cases involving children are some of the most difficult and sensitive that we have to deal with. Children are central to their parents' lives, but what we find is that they become too involved in the dispute between the adults in a way that shouldn't be allowed to happen. From my experience, I'd just like to give some tips to parents who are separating. What you must do is deal with the children first. So whether you're going through divorce or separation, before you deal with the finances, do put the children first. Custody and access no longer exist. They've been replaced by residence and contact. And it's not about the parents splitting the child's time between them, but about the child having the right to have a relationship with both parents and to spend time with both of its parents. In family law matters, and especially in children matters, you should try at all costs to avoid going to court. So do try all types of alternative dispute resolution, such as collaborative law and mediation, before you go to court, because it really is a last resort. If your child is over 9 years of age, they will actually have to go to court with you, and that's a very traumatic experience for a child, so do try to avoid it at all costs. If you do end up in court, the judge is going to consider what's called the welfare checklist, and that encompasses such things as your child's age, his wishes and feelings, and the ability of each parent to meet his or her needs. If you do manage to secure an agreement on contact, do think about things like not being late, do allow your child permission to enjoy the contact with the other parent, and above all, don't involve your child in your dispute.